Good morning, everybody. Thank you for joining us for today's online talk, which will be starting shortly at 11 a.m. For those of you who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Resolving Construction Disputes After the MCO. My name is Su-An. I'm an associate with Ma Wing Kwai & Associates, and I will be your moderator for today's session. Just a note, if you're one of those who registered early, you'll notice that the title of the talk when you registered was Resolving Construction Dispute by Adjudication. We have since revised the title to the current one. Not to worry, we will still cover the topic of adjudication in our talk. Before we start today's session, allow me to introduce the firm and what we do. Ma Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises of 22 lawyers and a support team of 19. Datuk Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicates some of our focus areas which are supported by talent from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 Movement Control Order, or MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is the 13th talk in our MWKA online talk series, which has been attended by some 2,750 attendees. Today, we're expecting 284 people who have registered. Visit our website at mawingkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute a legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, allow me to introduce both our speakers for today. Our first speaker is Ms. Hannah Patrick, a senior associate in our dispute resolution department. She holds a Bachelor of Law from University of Malaya. Hannah was admitted to the High Court of Malaya in 2013 and the High Court of Sabah and Sarawak in 2017. Our second speaker is one of our firm's partner, Ms. Christine To. She has 3 degrees and one of them is a Bachelor of Law from University of London. Christine was admitted to the High Court of Malaya in 2014. Besides being a practicing lawyer, she is also a certified accountant as well as a certified adjudicator and panel with the Asian International Arbitration Center. Our speakers hope to complete today's talk by 11:45 a.m. and thereafter proceed with the Q&A session. So if you have any questions, please don't forget to post them up on Slido and our speakers will address them later. You should have received a link to Slido during registration, but I will leave this slide up for a while so that you can scan the QR code before we move on. Alternatively, you can go to Slido's webpage and key in the code 31941. I repeat, 31941. The most crucial part of a construction project is not the materials or the workers. It is the terms in the construction contract itself. However, regardless of how stone-clad solids are the terms in the construction contract, it is still subjected to interpretation and external intervention, which may give rise to a construction dispute. This is especially true in light of the recent MCO, which has hindered the progress of construction projects nationwide. So the question now is, what are the avenues available to resolve such construction disputes after the MCO? For today's session, Hannah will first discuss the common issues which will arise in a construction dispute after the MCO. She will end her session by discussing the methods available to resolve those construction disputes. Our second speaker, Christine, will then discuss the recent developments in the law concerning the construction industry. With that said, I will now invite Hannah to share her insights. Over to you, Hannah.
Thank you, Suen. Good morning, everyone. Once again, thank you for joining us this morning. I'll begin by taking you through some of the heads of claim which we have identified that may arise due to MCO. They're largely similar to how it usually is. The only difference would be the grounds which we use to supplement these claims. We will go through 4 issues, which is time, the applications for extension of time. We will go through LAD, claim for variation orders, and claim for loss and expenses. The grounds, which is usually the suspension of works due to MCO, force majeure, etc., have been covered by us before in our previous talk. You may refer to this link. We have covered the grounds. In that link, you will be able to access frequently asked questions, as well as slides and video of the previous talks. Now let's go to time. Time is usually of essence in construction contracts, and the questions which we have identified which may arise due to MCO are as follows. Works cannot be completed within the contractual date of completion. What happens then? What if extensions of time are not granted? What if the certificate of non-completion are not issued? So if parties use standard form contracts, you will be able to find the provisions for time in the following clauses. For PAN, you may see in clause 23. In IEM, you may see in clause 20.3 and 44. And in PWD, you may find it in clause 43. LAD. What is LAD? LAD are damages recoverable as a result of non-completion of works or delay of works by the contractor. The questions which usually arise are, is LAD claimable? And is the amount claimed reasonable? Again, if parties enter into standard form contracts, you may find the relevant clauses on LAD. So for PAM, it's clause 22.1. For IEM, it's clause 46. And for PWD, clause 40.2. My partner later will cover the new developments in the law regarding LAD. Next will be the claim for variation order. What are variations? Variations are increase, decrease, omission, or substitution of works, or change in character or quality of work. You may find the provisions on variations in the following clauses in the standard form contracts. You will have to note the procedures and notice requirements under the standard form contracts, and honestly try to adhere as closely as possible to these provisions. It will make your claim much easier to be proven later on. Claim for loss and expenses. Now, claim for loss and expenses are reimbursements to contractors when they incur loss and expenses due to events outside the contractual provisions. These are the provisions. I have listed them down under the standard form contracts pertaining loss and expenses. These are the examples which we have also identified, which may arise due to the MCO. Demobilization and remobilization costs, site staff salaries, accommodation, utilities, rental for sheet piles, forklifts, excavators, and other plant equipment, as well as scaffolding. Issues of insurance may also arise from MCO. Now that we've identified the issues, what are the mechanisms that you as the contractors may available to you as the contractors? You may go to court. There are at least 3 lower courts that you can go to. The magistrate court, if your disputed claim is under 100,000. The sessions court would be for disputed claim below 1 million, and the high court for disputed claim above 1 million. Now we have 2 specialist construction courts that we know of in Kuala Lumpur and in Shah Alam. These are the judges who preside over these courts. Arbitration may be by prior agreement between parties in your contract, and adjudication. We will be covering statutory adjudication, but we are also aware that there are contractual adjudication provisions, especially under PAM. Let's go now to the construction adjudication under CIPAA 2012. CIPAA 2012 came into effect on the 15th of April 2014. The purpose of this act is to facilitate regular and timely payment by providing a mechanism for speedy dispute resolution. We highly recommend adjudication because it is timely from the service of the first cost paper up to the delivery of the adjudication decision. From our experience, it takes not more than 105 working days from the commencement to the conclusion. I will take you through the timeline later on. These are the essential characteristics of CIPAA. The procedure is summary and informal. No negotiations are involved. It is statutory procedure provided for under the Act. It can be both inquisitorial and adversarial. This happens when the adjudicator participates actively in inquiring for more information from parties in the course of adjudication. And when you compare to some court proceedings and arbitration, the time frame will relatively be shorter. CIPAA provides an interim or temporary solution until parties decide to finally decide the dispute in court or arbitration. What does CIPAA apply to? It applies to every construction contract made in writing relating to construction works carried out wholly or partly within the territory of Malaysia, including a construction contract entered into by the government. What is construction work is clearly spelled out in the Act itself. Now, what does the Act not apply to? It does not apply to contracts by a natural person for any construction works for a building which is less than 4 stories high and is wholly intended for his occupation. This was the time overview which I was mentioning earlier. Right, you can see here, parties serve the payment claim, and then an adjudication, a payment response is to be served within 10 days. And upon the issuance of notice of adjudication, the adjudication starts, you can see that timeline are mostly 10 working days in between, with 5 working days at the end for the adjudication reply. The adjudicator then has 45 working days to complete his adjudication decision. Now, the inquisitorial process may take place within this 45 days. So all in all, it's pretty much set out. And that is the attractive nature of CIPAA, because the timeline is quite set, unless parties ask for extensions of time. When an adjudication decision is rendered, it provides temporary finality to your dispute. What this means is that your dispute will be resolved as at that moment, but if parties decide to take it up to arbitration or court later on, they can. What if losing party refuses to pay? There are mechanisms as well under the Act and case laws to provide for mechanisms. First of all, there will be applications for enforcement under Section 28 of CIPAA. Now, the effect of this enforcement is that it may be executed in accordance with the rules of execution of the orders or judgment of the court. Now, what this means is that you will be registering the adjudication decision with the High Court, and then the decision will be treated as if it is a judgment of the High Court. And when that happens, you may be able to, you will be able to go under the rules of execution of orders under the rules of the High Court. So it will be enforced as if it is a judgment of the High Court. I hope that's clear. These are the other provisions under CIPAA 2012 which are unique to this Act. First, parties may use the adjudication decision to either suspend or slow down work pursuant to Section 29 of CIPAA. Parties may also, the winning party, may also claim for direct payment from the principal under Section 30 of CIPAA 2012. We've written an extensive article on this, and you may visit this link. My colleague will post the link on the chat, and please visit this link so that you will see the mechanisms of how direct payment from principal can be done. Under Section 35 of CIPAA, conditional payment or paid when paid clause are also rendered void. Therefore, it is prohibited under CIPAA for contracts to have conditions for payment. And Section 36 will have default provisions in the absence of terms of payment. And I believe it's 1 month or 30 days under Section 36 of CIPAA 2012. All right, I think I'm done. I will pass the time now to Christine, who will now speak on the recent developments in the law. Christine, over to you.
Thank you, Hannah. All right, good morning, ladies and gentlemen. Thank you very much for joining us today. And thank you, Hannah, for very informative sections and introduction as to CIPAA, as well as the common dispute that we have all heard so much during this MCO. So now I'm going to take you guys through this. There are some recent developments in law in relation to the construction industry. And I will try to make, because I'm going through judgment of the court, and hence I will try as much as possible to use less of all this legal jargon and to make it as a storytelling as much as I can to our participants today. First of all, applicability of CIPAA. So often it is very much oft quoted UDA holding, whether CIPAA apply retrospectively or prospectively. UDA holding is the first case decided under CIPAA, and it was held by Justice Mary Lim, as her ladyship was then, and she's now in the Court of Appeal. She held that UDA holding applies retrospectively, meaning if your construction contract was entered into before CIPAA came into force, i.e. 15th of April 2014, you can still go under CIPAA to claim for it, to make use of CIPAA. Well, so we have this first decision in 2014. Now, in 2019, 5 years down the road, the federal court took a different approach altogether. And in Jack in Pao Federal Court, which is the highest court of land, held that CIPAA is prospective, meaning if your construction contract was entered into before 15th of April 2014, then you can't go under CIPAA. There is an article on our website in relation to this case of Jack in Pao and how this CIPAA is now prospective. Please visit our website to have a look at the article. It's a short article, and basically I just summarize what happened now in terms of CIPAA and the construction industry. So the next question now is, we all know that there is a time gap often between the award, i.e. the LA, the letter of award, and formalization, signing of the condition of contract. Sometimes the LA will be given few months before. Then parties subsequently formalize everything by signing the condition of contract. And what happened now? Whether CIPAA applies to you? I'll take you guys through this case decided by Justice Wong Kin Keong. He is in the Shah Alam Construction Court. So what happened here is that the LA was concluded before CIPAA came into force. And then parties subsequently signed PAM. And the issue before the High Court, before Justice Wong Kin Keong, is whether CIPAA is applicable. So Justice Wong Kin Keong held that as at 8th of May, i.e. the date where the LA was concluded, parties already have their contractual right. And then CIPAA, which is a statute, came into play after the LA, should not impair any rights that parties have before that. So they have, and also parties have acted on their vested contractual rights and entered into several transactions based on those vested contractual rights. And with that, Justice Wong Kin Keong held that CIPAA is not applicable. The construction contract was already concluded before the date where CIPAA came into force. So this is a case that says CIPAA is not applicable. Then I'll take you guys through the second case, KLIAA. This case was decided by Justice Lim Chong Fong. Justice Lim Chong Fong is our construction, sitting in the construction court in Kuala Lumpur. This concerns a letter of offer. So similar to what we have previously, the letter of offer was before CIPAA came into force, and construction contract, which is the consultancy agreement, and third party entered into the consultancy agreement after CIPAA came into force. And I will take this opportunity to also clarify that consultancy agreement, i.e. agreement for architect, agreement called QS, also fall under CIPAA, because it was defined under CIPAA that construction contract is involved both construction work and construction consultancy agreement. So in this case, Justice Lim Chong Fong held that according to clause 5 of the LO, the letter of offer, party actually contemplated, you know what, we will want to negotiate more. This is the LO, but we thought that we want to negotiate more in terms of the obligation and terms between the parties. So it was, and that contemplation was actually stipulated in clause 5 of the LO. And not only that it was stipulated, as a matter of fact, parties further negotiate and eventually concluded the agreement on additional terms, and as well as there are some variants. So what happened in this case, the variance in terms of the terms was the amount and the calculation of fees. So Justice Lim Chong Fong held that the consultancy agreement is not a mere formality to formalize the desire of the parties. And he held that the construction contract was actually the consultancy agreement, which came into play after the enforcement of, after CIPAA came into force. And hence, CIPAA applies. So if you ask me, what happened if I have my LA or LO before 15th of April 2014, but I signed my contract after that? Look at these two cases, and that will say that it very much depends on the facts of the case. Every case is different. We need to look at what are the facts surrounding those cases and see and to determine where actually in fact that parties concluded the construction contract. The next area I'm going to discuss is about direct payment from principal. Again, Hannah mentioned that there's an article, Section 30 article that we have in our website. Feel free to have a look at it. Again, it's a short article, easy to understand, how it basically deals with how we can assist our clients in getting direct payment from principal. So some background facts about this case, City Indah Construction. So City Indah is a subcon for a project. The project name is called The Mark. BHL Gembilang, which is the respondent in that case, is the developer. So there is already a gap. There is a subcon, then there is a developer. So BHL Builder is the main con. So this is pretty common. This setup is pretty common in construction industry. I'm sure that it's no stranger to a lot of you here. So what happened is that City Indah commenced an adjudication proceeding against the main con, which is BHL Builder, and they obtained a decision. And then because by reason of the decision, the main con was ordered to pay City Indah 9 million by a particular date. So after they got this adjudication decision, City Indah requested for direct payment from BHL Gembilang, which is the developer, pursuant to Section 30. And BHL Gembilang ignored that request. And then BHL Builder, the main con, was then subsequently wound up by a third party. He wasn't, the main con was not wound up by City Indah. So now the main con is out of the picture. We left with a subcon with an adjudication decision, which worth 9 million. And then we have this developer on the other side who has been served with a request for direct payment under Section 30. So what happened now? In the High Court disallowed City Indah's application for direct payment against BHL Gembilang. So he said that the High Court said, nope, no direct payment from developer to subcon. And then City Indah is not happy with the decision, so they appeal. And then the Court of Appeal allowed the appeal, i.e., yes, there is direct payment from the developer to the subcontractor. And the issue before the court mainly is this, whether there is a preferential payment. Because the moment the main con is wound up, basically you have to line up with the rest of the creditor to get your debt. So by allowing this City Indah to get direct payment from the developer, would it contradict the preferential payment under the Companies Act? So the Court of Appeal say that, nope. Section 30 of CIPAA creates an independent statutory obligation to pay that is regardless, and hence the City Indah's appeal was allowed, and they can get direct payment from the developer. And this case was recently applied by, again, Justice Wong Kim Pyong in Cabinet. Music to the ears, isn't it, to a lot of subcontractors. Okay, now I'm going to move on to LAD. This is probably $1 million question, and I will try to make this as simple as possible. I have to admit that even as a practitioner myself, I find it challenging to understand and trying to consolidate trying to make sense out of all the cases that have been decided. So let's, a little bit of history first. We have Selva Kumar. Selva Kumar is a federal court decision, but this is in 1995. So what happened in Selva Kumar is the federal court held that an innocent party seeking to rely on LAD cost would have to prove the actual damage suffered. Yeah, this really sounds very legal, isn't it? So to put it in simple terms, let's say, for example, I put it in an example in terms of a construction contract situation. You have a main con and have a subcon. Okay, that is a LAD clause. So what happened and what Selva say is that for you, Mr. Main Con, to claim for LAD, you have to prove that you have suffered that amount of loss. So let's say the LAD in the contract is 10,000 per day. Okay, so main contractor, Mr. Main Contractor, you have to come to court and show to the court how is it that you suffer 10,000 per day because of Mr. Subcontractor's delay of 1 day. So in that manner, the court also has the court will say that you have to satisfy, it has to be satisfied that the innocent party must prove the actual loss before they can award the LAD, which parties already agreed. So that is Selva Kumar. Put it in a very simple term. Then we have cubic electronics, because for a very long time, basically it's very, very hard to exercise your right under LAD, although parties already agreed that if you delay 1 day, I'm entitled to charge for LAD for this amount of money. But in practice, because of Selva Kumar, the innocent party will have to prove actual loss of delay. And we all know that proving actual loss in terms of delay is a very difficult task. So then after cubic, this is another federal court decision, and it pretty much reversed the role. So the innocent party, let's move back to our example just now. The innocent party be the main contractor. The main contractor relying on the LAD will just have to go to court and show the court that, number one, there's a breach, subcontractor delay, and the delay was caused by the subcontractor. And then there is an LAD clause in my contract, and that's it, and it stops there. Then the burden moves to the subcontractor. Then the subcontractor will have to say that, will have to prove now that 10,000 per day is unreasonable. So if the subcontractor can't prove that 10,000 per day is unreasonable, then the court has the power to award a sum of not more than 10,000 per day to the main contractor. So the court will actually look at what is a reasonable compensation, being not extravagant, not exorbitant, and not unconscionable. The parties the court will also look at the concept of legitimate interest and proportionality. In terms of, let me see my timer, I have 10 more minutes. I want to share with you the background facts of this cubic. Okay, if we have time, we will come back to this. So let's move down to another area, which is, after cubic, now you have another court of appeal decision. I have only 10 more minutes. Okay, so this McVilla is more recent than the federal court decision, and it deals specifically with LAD. Cubic, the federal court decision, deals with deposit. McVilla deals specifically with LAD. So some background facts. The background facts of McVilla is pretty straightforward. McVilla it's actually a claim by LAD claim by home buyer against developer. So what happened in that case is that the court, let me set out some basic grounds first, some basic backgrounds as to the facts of the case, so that you all can appreciate it better. So McVilla is the developer, and the project is called Vision Residence. And then the first respondent is the home buyer for one of the condo. And the second respondent is, they actually bring in the tribunal for home buyer as well as a party. So what happened is that the first respondent, i.e. the home buyer, I'll use their party's respective role, then it will be easier to understand rather than calling them appellant, respondent, first respondent, second respondent. Okay, so what happened now is that the buyer actually go to the tribunal for home buyers and ask for a LAD because the developer failed to give VP within the time agreed in the SPA. The claim in this, for the first respondent in this, the claim by the home buyer in this case, is actually not much. It's only 38,000. But it's a very interesting, it's a very important issue before the court. What happened then? The developer say that no, you're not entitled for the LAD for a few reasons. And then one of the reasons given was because the developer gave rebate to the home buyer. So the purchase price is not, the actual purchase price is not the purchase price reflected in the SPA. This is also quite common in our construction industry. And then also the next ground relied by the developer is that although I delivered BP to you late, but within this time, I paid for your interest, your financier punya interest, I paid. So the developer appeared before the court and said that the home buyer will be unjustly enriched. I've already paid for the interest. And then even that, your LAD is calculated based on a price, the SPA price, which does not reflect the actual purchase price. Then before the tribunal, the home buyer didn't put in any further document to rebut whatever the developer has said. Even that, the tribunal awarded LAD to the home buyer. So the developer is not happy with the tribunal's decision, apply to the High Court for what we call a judicial review application. High Court dismissed, and then they appeal to the Court of Appeal. And then Court of Appeal also dismissed. So meaning that the home buyer now, as of now, the Court of Appeal actually allowed the home buyer's LAD claim. And in that case, Court of Appeal set down the methodology. They say that number one, if there is an agreed damage, there is a presumption that it is a penalty. Well, there is some, historically, there is difference between penalty and this stipulated sum. We will not go into that. This is very academic. So let's say if the defaulting party, now move back to the our case law here, the developer and the home buyer. So if the defaulting party, what the Court of Appeal is saying is that if the defaulting party, i.e. now is the developer objects the LAD clause, then the plaintiff, i.e. the home buyer, will have an obligation to prove loss and damages. If it does not successfully or succeed wholly or partly, the court has a statutory discretion to provide for reasonable compensation as opposed to nominal damages. Then the example given, what is reasonable compensation? So basically they are saying that the court will then decide what is reasonable if the plaintiff cannot prove the loss. So example given in the court was 10% of the value of property may be a reasonable compensation. And the court actually makes reference to standard form such as PAM and CIDB. And I've quoted what the court had said. The court should give due weight to the agreed terms, and the liquidated sum stipulated should be recognized, unless there are compelling reasons not to do so. I think by now everyone is as confused as ever. First, you have Selva Kumar, the first the federal court decision, which says that the defaulting party, i.e. the main contractor, will have the obligation to prove actual loss. That's Savakuma. And then we have Cubic, which says that developer, the main contractor does not have the obligation to prove. It is the contractor to prove that the LED cost is unreasonable. And then now we have McVilla, which says that the plaintiff now will have to prove loss. If you cannot prove loss, then the court will have the discretion to decide what is a reasonable compensation. Of course, the court also takes cognizance of this. The court should not put the innocent party to strict proof at the expense of public pursuit to the benefit of the defaulting party. One interesting statement made by the Court of Appeal is that it is best for the court to deal with the issue of compensation summarily to satisfy the stipulated sum is reasonable according to the market practice. McVilla is a Court of Appeal. It's a Court of Appeal decision. I have checked yesterday, up to yesterday, it has not been applied in any case law yet. We will have to see how courts look at this case and in terms of a claim under LED. This is a very heavy topic. Let's move on down to something less heavy, which is winding up an adjudication decision. Okay, I know my time is up already. I will just touch on this and we will proceed with Q&A. So Likas Bay, basically whether you can wind up a company based on an adjudication decision. So in Likas Bay and Binapuri obtained an adjudication decision against Likas Bay. And then thereafter, they served a statutory demand against Likas Bay. Then after that, they present a winding up petition. And the High Court allowed that winding up. So basically, they wound up Likas Bay, Binapuri wound up Likas Bay pursuant to an adjudication decision. You can put it that in that term. So Likas Bay is not happy with the decision by the High Court. They appeal to the Court of Appeal. And the Court of Appeal found that Binapuri was competent to file the winding up petition. And because Likas Bay has failed or neglected to pay the adjudicated sum. The Court of Appeal also say that it is not mandatory that you must get a judgment before you can wound up a company. The Court of Appeal also takes cognizance of the fact that Likas Bay did not apply to the High Court to set aside the decision. Basically, they just sit there and did nothing. And Court of Appeal held that it was just and equitable for High Court to grant the winding up petition against Likas Bay. This is a Court of Appeal decision. So after Likas, I have also advised my client, once you get the decision, you can serve a statutory notice under Section 466 of Companies Act to the defaulting party. That is after Likas Bay. And then recently we have a decision of ASM. ASM is a High Court decision. It was decided by the Justice Daragun. So a little bit of, I'm going to finish it up. A little bit of background. ASM was appointed by Econ Power as the main contractor for a project. So they won in CIPAA, and then the Econ Power then issued, so Econ Power commenced the adjudication proceedings against ASM. Econ Power won, and then they served Section 466 notice, which is the notice of statutory notice demand against ASM for the adjudicated sum of 67 million. That's on one hand. And then on the other hand, ASM ran to the court and say that, no, you must not let Econ Power present a winding up petition against me. So this is a different kind of application, which is what we call a fortunate injunction. So what happened in a fortunate injunction is that you restrain people from presenting a winding up petition against your company. High Court actually allowed ASM injunction. So now look at it this way. We have litigants who say that you can wind up a company based on an adjudication decision. And now we have ASM who say that similar in the sense that there is an adjudication decision. But in ASM, the High Court allowed a fortunate injunction, i.e., EconPal could not present a winding up petition against ASM. At first glance, looks like these two decisions contradict each other. The reason why High Court allowed, but I have to say that the facts of both cases are very different. One, in Lickers, the respondent, the defaulting party, basically did nothing. He just sit down there and did nothing after they got after there is a adjudication decision against them. Whereas in ASM, there is a pending arbitration, okay? And then the High Court allowed ASM, High Court found the ASM dispute of EconPal's claim are bona fide and upon substantial ground. The High Court actually looked at the factual metrics between the parties, and they actually looked. His lordship actually looked at the fact that during pendency of the CIPAA proceeding, parties already served notice of arbitration against each other. You serve a notice of arbitration against me, I serve a notice of arbitration against you. There is a substantial claims between each other. Parties are fighting, and ASM LAD claim is 142 million, and it's based on a certificate of non-completion issued by the architect. The adjudicated sum was 67. The LAD claim by ASM is 142. That's one thing that the court looked at. Number two, there's actually notice of default issue by ASM because of EconPal's suspended work, abandoned the project. So what Justice Daragun held is that clearly there are dispute and argument against each other's claims. So, but however, they, based on the evidence made available, I'm of the view that the plaintiff's dispute of the defendant's claim allowed by the adjudication decision and its counterclaim and set-off are bona fide and upon substantial ground. Whether the plaintiff will finally be successful is a matter for the arbitrator, and I'm not required to, and I express no view on this. So this was decided by Justice Daragun. So he thinks that between the parties there are disputes, there are bona fide disputes upon substantial grounds, and hence he allowed the fortunate injunction. I'm aware that this case is currently appealed to the Court of Appeal, and there's no decision yet. If there is once the decision is up, I will update, and I'll update all I'll have updates. Okay, pretty much cover everything that I want to cover. I'm sorry I hold you all up for a while. Now we will move on to Q&A, and back to you, Suen.
Thank you, Christine and Hannah, for sharing with us. We will now take questions that some of you have posted on Slido. Remember, you can ask us questions on Slido either by scanning this QR code or going to Slido's webpage and key in the code 31941. Our first question for today, construction delay during MCO, can it be considered as force majeure, and how it impacts to the CIPAA procedure and award? Hannah, would you like to take this question?
Okay, thank you, Suen. Now, whether delay during MCO can be attributed to force majeure really depends on the terms and conditions of the contract and the definition of force majeure event in your contract. For example, if parties use PAM, there is a word epidemic in the definition of force majeure. That is arguably, you may link epidemic to COVID-19 MCO. So it's an arguable case. It depends on each contract. Now, whether CIPAA procedures are affected by MCO, the answer is no. Days will still be calculated accordingly, according to the Act. However, you may want to consider some practical issues if you wish to either commence an adjudication during this period. Now, some of the practical issues we have seen is that for example, the service of payment claim. Payment claim is the first document that you draft and serve in adjudication proceedings. Now, this document has to be left, for example, at the office, the business office of the non-paying party. Now, when that happens, there's nobody to accept service. These are the practical issues that you have to consider. And the next thing would be, for example, if you need to prepare your claim, and when you need to prepare your claim, you will have to look into documents, and these documents may be in your office or your site office. These are also, your access to these documents may be impeded by MCO. So these are the things you may want to consider. Back to you, Suen.
Okay, thank you, Hannah. For our next question, MainCon has obtained MITI approval to resume work. If the subcon refused to apply to MITI with the intention of not resuming work due to the high health risks affecting their workers, can the MainCon impose LAD against the subcon? Christine, would you like to take this question?
Sure. Thanks, Suen. Okay, again, on the issue of LAD, as I have shared earlier on, I have to say that there is uncertainty in terms of the law of LAD, whether you can claim and whose burden is it to prove. That's one thing. But let's look at this on the issue of if the subcontractor do not want to refuse to apply to resume work. First of all, I think they obligate that it is not mandatory. It's not mandatory for them to apply. It is rather discretionary. Whether the MainCon can pretty much force them to apply to resume work is one question. And the second issue is actually mitigation. It is true that the subcontractor has the obligation to mitigate the loss, i.e. the disruption of further delay. So you want to start work fast enough so that you can mitigate that loss. Having said that, if you turn the other way around and say that, hey, look, if I start work now and then my worker got contracted and then I have to, there's even further delay cost to the progress of the work. So it's really pretty much depends, you see. I can't say if you can, yes, the MainCon can claim LAD, no, the MainCon cannot claim LAD. I think that the mitigation factors in both ways have to be taken into consideration. Back to you, Suen.
Thank you, Christine. Okay, our next question. MainCon has adhered to all the SOP issued by CIPAA. If a worker contracted COVID-19 outside the workplace and unknowingly without any symptom goes to work and spread the virus at the workplace, if he is found to be the source and has to bear for all the consequential costs, what are the remedies he has? Christine, can I have your views?
Sure. First of all, I think this is the bearing of the consequential cost, I believe is the SOP issued by CIPAA. So pretty much, if you agree to all this and so that when you in order to apply for your permit to resume work, pretty much you have taken that risk. So if you have to agree to that, and I think this is the risk that you have to take. If you are not willing to take this risk, then don't resume work. That's my question. That's my answer. Thank you, Suen.
Okay, thank you, Christine. Our next question. Please guide us on the step-by-step measures to be taken by the contractor now in safeguarding us from being made scapegoat by the client due to MCO, especially on LAD, payment issues, and loss and expenses. Hannah, I believe you can take this question.
Yes, I can. The question is quite broad. My answer for that would be, it really depends on the terms that parties have agreed. Now, each contract should have provisions for LAD, payment issues, loss and expenses. Follow the procedure set up in this contract. Follow the time and notice requirement also in the contract. The contract should, especially the standard form contracts, should have step-by-step procedures which parties can follow.
Thanks, Hannah.
Yeah, back to you, Sylvia.
Okay, our next question. We will suffer due to remobilization and loss of workers and materials due to prolonged MCO. Example, cement that hardened. Can we make a claim under what provision of contract can we write to the client? Christine, can you let us have your thoughts?
Sure. First of all, this sounds like remobilization and the fact that the cement got hardened. This sounds like a loss and expenses claim to me. So first of all, loss and expenses claim, you need to look at your contractual terms and see if there is a contract, there is a provision for it. There is no common law as of right that you can claim for loss and expenses or you cannot claim for loss and expenses. You need to look at your contract and see if you can claim for it. It very much depends on the terms of your contract. And under what provision of contract, that will depend on your terms of a contract. It sounds like a loss and expenses claim to me. So you can have a look at your contract and see under the heading of loss and expenses.
All right, thanks, Christine. Our next question. Most conditions of contract by the client are hybrid in nature, i.e. a combination of standard JKR or PAM to suit to their advantages or make it very difficult for the subcontractor to defend their position, even with force majeure situations such as this MCO. What is the best legal way to discredit this hybrid COC? Hannah, can you let us have your thoughts?
Sure. Okay, maybe to answer this, I will probably just take parties back to the purpose of entering a contract and how it's entered. Contracts are usually entered at an arm's length, and what that means is that parties have agreed prior to signing the contract to the terms. So whether it's hybrid or not, parties would have agreed at the beginning. If you're not happy with the terms and you wish to renegotiate the terms, then renegotiate it. Don't enter into the contract. And at this point, I would like to say that if it's crucial for you to get some legal advice, then go ahead and do it. It will benefit you in the long run. And if you're so that's how you enter into contract, by agreeing to the terms. Yes. Now, if you have already entered into the contract, there is no way but to be bound by it. Okay, back to you, Swen.
Okay, thanks, Hannah. Our next question. Under the JKR design and build contract, would the MCO be a valid reason to claim for EOT? Christine, can we have your answer?
Sure. I have answered this question actually in my previous sessions, and this can be found in our article. The short, you can refer to our article. I think we have a link to that, right?
Yes, the link is posted.
We already provided. Yeah.
Okay, then we'll move on to the next question. Since now the government allows contractors to resume work with conditions of getting an approval, does this mean force majeure is not applicable anymore? Hannah, would you like to answer this?
Okay, let me look at this again. Well, force majeure would probably still apply for the period where you did not work. So contractors are allowed to resume work after a certain period of time. There will be periods of time where you did not work. And if you wish to claim for periods where you did not resume work, and there is issues in between resuming work, you can apply for force majeure. Christine, do you have any more thoughts? Do you want to add to that?
Again, I think that the whether to apply or not to apply is again discretionary. But again, like what I have touched on just now, there is an obligation on everyone in the construction, in that particular construction project, to mitigate loss. So it very much depends. If let's say, for example, your construction site is at like red zone, you go there and you put everyone at a very high risk of contracting COVID-19, and at the end, if let's say because of that, someone in the one of the workers get contracted and is spread to the workers in your construction site, and that further delay the progress of the construction work, that will counter effect, you see. So it really very much depends on the facts of your case, whether you have the duty to to adhere or you have the duty to apply to mitigate those laws. And now I understand that the progress is very much affected already. But by you forcing someone or by you resuming work, will it cause the delay further? That is the question.
Yeah, maybe I also want to add, MITI does not compel industries to apply for approval. So it really depends on the capacity of each company or contractor, whether they can take up or meet the requirements to apply for approval, sorry.
All right, thank you, Hannah and Christine, for your answer. I believe this is a continuation from our earlier question. What happens if the subcontractor of the subcontractor refuses to work for health reasons? Can main con impose LAD? Christine, would you like to answer this?
Sure. Again, then the issue of LAD, as what I've shared in terms of the law, is still pending application of how the court look at MWKA. If you just have to we have to look at how the law developed in terms of the different approaches taken, one by the federal court in Quebec and another by the Court of Appeal in MWKA.
All right. Thank you for the answer, Christine. As we are now running short on time, we will end this Q&A session with the next 2 to 3 questions. Okay, our next question. What is employer's risk under IEM form? Perhaps Hannah, you can answer this.
Okay. The employee's risk, hang on, let me just pull out IEM and then
I believe that Hannah, if I may interject, I think this was also answered in our article.
Yes, it was. Employer's risk is part of our previous talk. The link is on the chat. But to answer, yes, it may amount. The answer to that, there is any operation of forces or nature which an experienced contractor could not have reasonably foreseen or priced for. This is 24 sub 1D in the IEM form of contract. Now, forces of nature can amount to force majeure. It really depends. Yeah.
All right. Thanks, Hannah. And a continuation to that question. IEM without force majeure. Contractor to claim EOT using clause 44 1B or C?
I think I've answered it together.
Okay.
It's C. It's D actually. It's D.
Okay. Thank you, Hannah. Next question. Can main con claim for loss and expenses during MCO? Christine, can you let us have your thoughts?
Sure. Again, as I've said in the question just now, whether one can claim, it does not depend on main con or subcon or whoever. Any contractor, whether can claim for loss and expenses for MCO, it all boils down to your contractual terms. In terms that also was addressed in my article. Per se, common law, there is no right for you to claim for loss and expenses. You have to derive this right contractually. So you have to look at your contract and see if there is a provision for you to claim for loss and expenses arising from this MCO.
All right, thank you, Christine. Our last question for today. If MCO is classified as force majeure, will EOT be automatically granted without notice?
I
can take that.
Oh, okay.
Yes, because that's an easy question. So both of us was like, okay, I can take this.
Go ahead, Christine.
Okay, let's say on the assumption that you are saying if MCO is classified as force majeure. First of all, there is no classification per se. You have to look at the terms of your contract. I'm assuming that MCO falls under a force majeure event for your contract. And then, yes, you will be entitled. And again, whether this force majeure, it can be force majeure for EOT, force majeure for loss and expenses, you see. So the relevant event. Say, for example, okay, this MCO is a relevant event for you to apply for EOT. Then whether it is automatic or not. Again, depends on the terms of the contract. But I have to say, based on my perusal of the pretty much standard form contract in commonly used in Malaysia, such as PAM, IEM, and your PWD, and usually EOT won't be a matter of automatic. You have to apply for it.
Yeah.
That's my answer.
All right. Hannah, anything to add?
No.
Okay then, and that's the end of our Q&A session for today. Thank you, Christine and Hannah, for your insights.
Thank you, Sven.
Thank you everyone for joining us.
All right. Before we conclude, I have a few announcements to make. First, please join us again for our upcoming day. Our associates, Ms. Vivian Fan and Mr. Wong Chi-en, will give a talk on arrest, remand, and bail during the MCO. Then on Wednesday, I will be speaking with our firm's partner, Mr. Gan Chong Che, on the topic of debt recovery during and after the MCO. Later on Friday, our senior associate, Mr. John Chan, will speak on unfair and constructive dismissal claims due to payment cuts and retrenchment. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. We will appreciate your comments so that we can continue to improve our MWKA online talk series for you in the future. Thirdly, please do follow or like our social media accounts. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30 minutes consultation over the telephone or over video conference. Please fill in the form on our website. The link is also posted in the chat. Finally, to our guests, thank you for joining us. We hope you have found today's session informative and useful.
Thank you everyone.
Thank you everyone for joining us.
Okay, thank you everybody, and we hope to see you at our next talk. Stay safe and have a great day.